Hello everybody, welcome to a brand new video, and I actually use new sparingly. So if you're a repeat viewer, you've probably realized by now that this is a re-upload, and that would actually be false. This is a remake. Now, I've come to understand that the quality on those few videos that I've uploaded so far has not quite been up to my expectations. And that's actually a shame because those videos are on topics that I, number one, care a lot about, and number two, find to be very interesting. So, in order to do those topics justice, I found it to make sense to actually completely rebuild those videos from the ground up. So if you've already watched those videos, I ask that you probably watch this one too, because it will be a lot better quality. Now that being said, today we are going to be talking about mandatory binding arbitration clauses and class action waivers. So stick around, and hopefully you can learn something here today with me. Hello everybody, here we are at the presentation, and I've got my glasses on, so let's get into the law. And it's actually been a while since I've glanced at this presentation that I've created, so I'm going to be refreshing myself while also explaining it to you. So let's get into it. What exactly is arbitration? Well, it's actually an alternative dispute resolution method. Now, what is an alternative dispute resolution method, you may ask? Well, it's basically any method other than traditional litigation that people can use to resolve disputes. And it's usually faster and less expensive. And down here, I actually have a study, quoting a study from the American Arbitration Association, which basically found that U.S. district courts take on average an extra 12 months when compared to arbitration to get to trial. So as you can see, it's usually faster to resolve disputes through alternative dispute resolution methods like arbitration rather than going through traditional litigation. Now, on screen here, I actually have a picture of Judge Judy, if you're familiar with that show. You've probably watched it and realized it might be a little bit unrealistic. She goes through cases a little fast and probably isn't as professional as you'd expect in an actual courtroom setting. She usually talks down to the people a lot, and it's a funny thing to watch. There's a lot of drama. But what you probably don't know is that she's not actually a judge. Well, she might be a judge, but on the show, she doesn't act as a judge. She's more so acting as an arbiter. So when you're watching that show, you're watching arbitration. And I've almost neglected to mention one of the most advantageous parts of arbitration is that it's less expensive. So that's one of the big reasons why companies prefer arbitration compared to other forms of litigation, because it helps save on cost. And so let's get into what mandatory binding arbitration clauses are. So these are usually clauses that are found in contracts, terms of service contracts, employee contracts, terms of use contracts. And these clauses basically mandate that all disputes be settled through arbitration. So basically, any dispute that you have with whoever you're signing this contract with, you can't traditionally sue them. You can't go through litigation to try to resolve any kind of dispute. You have to go through arbitration first with them. It's part of your contract. And there's several reasons why they include these in their contracts. And we'll get into that in a little bit. But yeah, basically, these clauses restrict signees from seeking out other forms of litigation or ADR, alternative dispute resolution methods, and they're actually often accompanied by class action waivers. So, what is a class action waiver? Well, class action waivers forbid signees from joining class action lawsuits. It's another way that they restrict your ability to become whole. They restrict your ability to seek litigation. So, what are the problems with this? Well, obviously, there's many problems with this. So, first of all, appealing the results of arbitration is difficult. Therefore, injustice is more likely to occur. So, make sure you understand that. Typically, when you're going through a courtroom, if you're in a trial court, you can attempt to appeal any decision that's handed down. You can go to your state appeal courts. You can go to federal circuit appellate courts. So there's always a way to appeal things within our justice system. It's baked into our justice system, actually, because we recognize that not every ruling that's handed down, not every decision that's made is a just one. There's going to be mistakes. So we have an appellate system for a reason. But with arbitration, it's not so easy to appeal decisions. So therefore, any injustices that occur are very likely to stick. And also, arbitration is far more confidential. So if a consumer or employer goes into arbitration over an injustice, others may not be aware that they are also victims. So let me break that down for you. There's an example that was actually given in a law textbook that I have, and it's basically this. So imagine you're going to court with your credit card company because they've been overcharging you. Well, if you do this through the traditional legal method, court cases are public. So other victims may be likely to see your case and be like, huh, maybe I should check if I'm also being overcharged by this company. And then if they are, they're able to throw themselves in there and try to become whole themselves. But if you go through arbitration, those are a lot more private, they're a lot more confidential. So in that case, if you went to arbitration with your credit card company to become whole, other victims will probably not even be aware that this is an issue, and they won't think to look out for themselves. So that's a problem. There's a reason court cases are public. It's for reasons like that. And another problem with mandatory arbitration clauses is that the need for employment is realistically inelastic. So this is where I argue that mandatory binding arbitration clauses are actually predatory, because no one, I don't believe, in my opinion, I don't believe anyone's ever seen their employee contract and been like, oh, there's a mandatory binding arbitration clause in here. I'm not going to sign this contract. I'm going to turn down this job that is otherwise mine because I don't like this clause. No one, I don't think, has ever done that in the history of employment. So basically, people can be made to sign contracts with these clauses without even giving it a second thought. No one really realizes how bad of a thing that these clauses are, and no one's ever going to turn down a job just because their contract has a clause like this. So, in that sense, I think that they're pretty predatory. And are they unconstitutional? And I actually argue yes, the mandatory binding arbitration clauses and class action waivers are unconstitutional. So, we have to first discuss where the right to sue comes from. And the right to sue, which, it's a joke. In America, we all sue each other. It's literally ingrained into our minds. It's one of the core American rights, something that we're all super patriotic about. But where does it come from? Well, it comes from the First Amendment of the U.S. Constitution. Where else? The most patriotic amendment of the Constitution. And that's because within the First Amendment, it's actually written that Congress shall make no law prohibiting the right of the people to petition the government for a redress of grievances. So I know what you guys are probably thinking. Doesn't the First Amendment have nothing to do with private businesses and corporations? Like, the First Amendment only applies to the government. They can't restrict you from suing other people, but maybe private businesses can because they're not bound by the First Amendment in the same way that the government is. And yes, that is true. However, the judicial branch has consistently upheld mandatory binding arbitration clauses, violating the First Amendment's implied right to sue. So, my argument essentially is because the judicial branch has upheld mandatory binding arbitration clauses and class action lawsuits through, class action waivers through decisions handed down, they are themselves violating the First Amendment. That is, in a sense, the government violating your First Amendment right to sue by upholding these practices. So, and I also say here, even though the First Amendment technically says it only applies to Congress, it's actually been interpreted to apply to the entire federal government. You probably know that. You probably understand that. Don't need me to explain it. But just to be as transparent as possible, and here we are. This is actually a court case where the judicial branch found that these clauses and these binding agreements were lawful. So this is AT&T Mobility Limited Liability Corporation LLC v. Concepcion. And this case actually upheld mandatory arbitration clauses, which included class action waivers. So basically, it's basic. So California, I think this case is about, the state of California had legislation on the books that made it so that those binding arbitration clauses with class action waivers were unlawful. The state of California tried to ban those practices. However, that case went to the Supreme Court. Someone challenged it, and basically the Supreme Court found that, hey, California, you can't ban these practices. These practices are actually lawful. Might be the one good thing California has ever done. Let's be real. So basically, this ruling preempted state laws that prohibited those practices, like I just said. And preemption is basically a way where you restrict smaller governments in a federal system, where you restrict state governments or local governments from regulating an issue. So now the federal government is the only one that has power to regulate an issue. That's preemption. State governments can do it too. So state governments can preempt an issue from local governments. So local governments like county governments, city governments can't legislate on an issue. Only the state government can. It's just a way of making sure that all the governments below you can't regulate an issue and only you can. That's preemption. You're basically preempting their ability to regulate an issue. And I actually believe that this case is an example of the judicial branch violating the First Amendment. Because, as I've already explained, it's them upholding a practice which violates people's First Amendment, the right to sue. And that violates the First. I mean, there's no way to better explain it. It's them violating people's First Amendment rights. People have a right to sue. And they've also further enforced these binding arbitration clauses and class action waivers in a case called American Express Company versus the Italian Colors Restaurant. But I'm not going to go into that case because we have another case to talk about, and that is Epic Systems Corp v. Lewis. And Epic Systems Corp v. Lewis dealt with whether it was okay to deny employees collective arbitration. So let's talk about why collective arbitration, first of all, is very important. Well, obviously, people have found that they're stronger as a collective. So that's why class action lawsuits are so widely used and important. Because most of the time, people are going up against companies that have far more resources and lawyers than the individual does. So let's say when you look at class action lawsuits, the only way to really enact any kind of meaningful change or seek any kind of meaningful compensation is to unite, to form these class action lawsuits where the average person can join with other average people to challenge these powerful corporations and businesses. So that's why collectivization in the terms of the legal world is very important. But Epic Systems Corp v. Lewis did away with collective arbitration because it actually ruled that arbitration clauses mandating individual arbitration and class action waivers were allowed. So therefore, now, within your arbitration clauses, it's likely that it actually mandates specifically individual arbitration. You can no longer lump your case in with other people. You have to face these companies and these corporations and your employers alone. So now we have to talk about whether or not these clauses and waivers are unconscionable. And I argue that they are. So first of all, what exactly does that mean? Well, unconscionable in legalese basically means something is without consciousness, or that it's unfair and wrong. And I argue that these clauses are, as they only hurt employees and consumers while benefiting big businesses and corporations, and because they restrict the signees' First Amendment rights while giving businesses a more confidential and inexpensive alternative dispute resolution method compared to traditional litigation. So, what exactly are my final thoughts? Well, pay attention to what you sign because you will find mandatory binding arbitration clauses in a lot more places than you'll probably expect. I've actually come to notice them in terms of use agreements when you first launch a video game. So if you've ever played a video game, nowadays when you first launch them, you have to scroll all the way down this long contract and press accept. And I've actually noticed that they have mandatory binding arbitration clauses in those contracts now. And another one of my thoughts is that the First Amendment is being increasingly toppled in favor of large businesses and at the expense of the common man. And I don't believe that's a good thing. I think that's something that people need to be aware of. And one of the points of this video is to spread awareness of these clauses and of these waivers and how they actually infringe on our civil liberties. So ultimately, guys, I want to thank you guys for watching. And I'm a brand new channel. I'm trying to fight the algorithm. I'm mostly just making these videos for fun. They're helping me learn. They're a great supplement to my current education. But I also want to build a small community of people who care about these issues, of people who want to have discussions about these legal topics. So if you could please like this video, subscribe, maybe spread awareness, maybe share these videos with people who also would maybe be entertained by them or would want to learn about the topics that I'm talking about in them. If you could do any of those things, I would greatly appreciate it. And thank you guys for watching, and I hope you guys have a great day.